We do different.
I like your.
All right. Continuing session, present.
Good morning, you may be, or good afternoon, you may be seated. Calling the cases of People versus James Carl Case III, file 18-6021-FH and 20-6477-FH. Would counsel identify for the record, please?
Good afternoon, Your Honor. Mark Webb on behalf of the people.
Please, the court, Scott Moore for the defense.
And sir, would you raise your right hand to be sworn?
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Could you tell us your name?
James Carl Case III.
Mr. Case, you appear here today to be sentenced in each one of these two files. In file 18-6021-FH, previously you appeared in court and at that time you pled guilty to violating the terms of your probation. You currently are on probation to this court in that file for the 10-year felony crime commonly known as possession of methamphetamine. Therefore, the maximum penalty the court could impose is 10 years in prison. The minimum sentence is discretionary with the court. The applicable sentencing guideline range is 0 to 6 months, although pursuant to People versus Lockridge, those guidelines now are advisory instead of mandatory. And the Clare County Circuit Court Probation Department and Michigan Department of Corrections have prepared an updated probation violation report in that file. In the other file, in file 20-6477-FH, you appeared in court back on July 13 of 2021, and at that time you pled guilty both to the felony crime of delivery of methamphetamine and you also pled guilty to being a habitual offender through defense notice. Delivery of methamphetamine is a felony. Normally it carries a maximum penalty of 20 years in prison, and the minimum sentence would be discretionary with the court, but when coupled with a conviction for being a habitual offender through defense notice, which is the vote in which you find yourself, Mr. Case, the net effect of those things is that the court in its discretion may double the maximum penalty from 20 years in prison to 40 years in prison. It's discretionary with the court whether or not to double the maximum end of the sentence, and regardless of whether the court does so, the minimum end of the sentence would be discretionary with the court. The Clare County Circuit Court Probation Department and Michigan Department of Corrections have prepared a pre-sentence investigation report in the 2020 file, as well as a sentencing information report. And in those two reports, at least thus far, the departments calculate your applicable sentencing guideline range to be 78 months to 195 months, or put another way, 6.5 years to 16 years and 3 months. Those guidelines, of course, apply only to the minimum end of the sentence, not to the maximum end of the sentence. which could be as high as 40 years. And in any event, pursuant to People versus Lockridge, those guidelines also are advisory with the court. They are no longer mandatory. Mr. Moore, have you, how did you want to proceed today, sir?
Thank you, Your Honor. Mr. Case and I did begin to review the pre-sentence investigation report. It indicated to me that he wishes to withdraw his plea, that he is claiming innocence, that the agent's description of the event, the offense would support that position. Further, it is anticipated that he would be stating that he was ineffectively assisted by counsel when he was advised to accept the plea. So for those reasons, the defense is requesting to withdraw the plea pursuant to MCR 6.310, subparagraph B, subparagraph 1.
Have you filed a written motion to that effect?
I have, Your Honor, it should be in the court file. If you could please the court, I may provide a copy.
Sure, thank you, sir. Mr. Webb, do the people have a position as to the defendant's motion to withdraw a guilty plea?
Well, certainly, Your Honor, we would object to that, but we'd also like some time to file a written response if the court's going to entertain this today. I believe in paragraph 3 of the motion, the defendant states that the plea was based on inaccurate or misunderstood advice and claims innocence. That's a pretty general statement that I believe a lot of defendants would make at this point if they're looking at going to prison. I think it takes more than that. The pleading has to be more specific than that in order for that to be successful. But nevertheless, if you're going to entertain this motion, I would ask for time to respond and leave the a hearing may be called for.
I may respond briefly to the.
Sure.
Thank you. Well, I concur that this is a pretty thin motion as they go, but often when these pleas, these requests to withdraw the pleas are made, there is no written motion at all. It's done on the fly in the courtroom. I acted with all due deliberate speed. I met with Mr. Case today at the jail between 12:47 and 12:53, and then spent the balance of the afternoon researching this question and drafting the motion. As regards the factual allegations that are made, it seems to me that in the case of People versus Bailey, Michigan Supreme Court case reported in 503 Michigan Reports 940 in 2019 case, the Supreme Court remanded for an evidentiary hearing to determine whether defense counsel advised the defendant that she would be able to withdraw her plea prior to sentencing and if her plea was then voluntary. I think that this came out of the Macomb Circuit, and I believe, looking at the case, that it was the understanding of the court, trial court, and the litigants that more had to be adduced at that hearing, much like what we're doing here today. The Supreme Court is saying that factual development of those questions is a condition preceding to the court making a decision to grant or deny the relief requested. So that's why we've done things the way we have here. And I recognize Mr. Webb's position. Yes, we are catching people somewhat flat-footed. However, I needed to make this motion as directed by my client. Thank you.
Thank you, sir. And of course, everyone, except perhaps the defendant, since he's not, to my knowledge at least, he's not a trained lawyer. Everyone in this room is well aware that it becomes even more difficult to seek to withdraw a plea after sentencing as opposed to beforehand. And it's hard enough to seek to withdraw a plea beforehand. It becomes even more onerous after the sentencing has occurred. So certainly the court is not the least bit critical of you when your client advised you at the last minute that he thought perhaps he would like to withdraw his plea and go to trial. roll the dice and perhaps, if acquitted across the board, go home a free man. Although that would require, of course, being acquitted of the probation violation charges as well, where the burden of proof is a simple preponderance of the evidence. But on the other hand, if he were to be convicted, he could be facing a far lengthier sentence because there would no longer be any sentence cap. And in this particular case, court is not sure what it would do regarding whether it would honor that sentence cap or not. But in any event, this is America, it's a free country. People are free to make their own decisions, and for that matter, people are free to make their own mistakes. And so, because the defendant apparently got cold feet, as it were, at the last moment, and communicated his desire to seek to withdraw the plea to his lawyer in an untimely, last-minute manner, the lawyer then, on the fly, did research and prepared and filed a written motion. But of course, that was only served on the prosecutor today. Taking into account all of those circumstances, the court will grant the prosecutor's request. I will adjourn sentencing. And you've indicated, I think it was Mr. Webb, or actually it might have been you, Mr. Webb. One of the attorneys had indicated perhaps there have to be some testimony taken, or at least a period of time devoted to a hearing on this motion. Is it something that would be better to address on a motion day?
I don't think there'd be enough time with a motion day. Well, I don't.
Oh, no, I don't.
I mean, hear a motion on
I
a motion
was
day?
not
That's
the-
ridiculous.
I was not seeking to be, I was not as poker faced as I perhaps would like to have been, but my mirth was not entailed because I fully expect this will be more than a 20-minute motion. But in any event, then I will adjourn today's sentencing without date. I will have my assignment clerk schedule the matter for a hearing. If you wish to file a more detailed written motion, feel free to do that.
Thank you.
And
Well, and that
but
raises,
I'm not implying that you need to either. But if you do file such a motion, do you want a period of time to decide whether to file such a motion? And if so, how long?
well, as I indicated, or alluded to when citing this case law that's cited in the motion. Ineffective assistance of counsel in itself is not, in most cases, sufficient grounds to allow a defendant to withdraw the plea. But ineffective assistance coupled with a matter that goes to the voluntariness of the plea, such as a claim of innocence or a reasonable dispute, the weight of the evidence people can bring to bear, then it becomes a much more difficult decision for the trial judge. And the case law would suggest that if you have that 1-2 combination, withdrawal of plea would be appropriate. This is all a long-winded way of saying that my client has lost confidence in me. He has told me that he believes that this is a beatable case. He, I believe, has received counsel from another attorney who is in his employ on another matter. it's clear that Mr. Case has lost confidence in me. I don't believe that I can effectively represent his interests by his lights. And I frankly, Your Honor, the 2.0 version of this motion would almost certainly have me and my performance as Exhibit A. And it's always hard to bring your own robe to the execution. So I think for all of these reasons, the court should consider allowing me to withdraw as counsel so that my client can get all day in court without let or hindrance. Thank you.
Well, Mr. Case, you earlier on in proceedings had indicated you wanted to have a lawyer represent you. You indicated at some point that you did not have the money to hire your own lawyer, and you asked the court to appoint a lawyer for you, and the court ultimately appointed Mr. Moore. Do you want Mr. Moore to continue to represent you, sir?
No, can I get a different lawyer?
I don't know. Do you have any money?
No.
Okay, so you're not. So I guess the short answer to your question is you have said, I guess I should try to tease out what your position is. You do not have the money to hire a lawyer, correct?
Correct. I can try to get a hold of my people and see if they can come up with money.
And you still want to have a lawyer represent you, correct?
Yes, sir.
You would prefer to have a lawyer other than Mr. Moore.
Yes, sir.
And has there been any kind of a breakdown in communication between you and Mr. Moore? Because he seems very well prepared on this case, and he seems to be presenting your position here very ably. But you would prefer a different lawyer, correct?
Yes, sir.
And you don't think you're going to be able to hire a lawyer?
I'm not really for sure yet. I'd have to talk to my family. But as of right now, no.
All right. And knowing all of those facts, you want me to remove Mr. Moore from this case and relieve him of his obligation to defend you?
Yes, sir.
Very well, I will grant that request. And Mr. Moore is relieved from his duties in this case. And you have made it clear, Mr. Case, that you might be able to raise the money to hire your own lawyer. And if not, then at some point, you're going to be asking for another court-appointed lawyer, is that correct, sir?
Yes, can I get another court appointed?
Well, in the normal course of events, if you don't have the money to hire a lawyer, yes, you would. You'd be entitled to a court-appointed lawyer, but you've just told me twice, I believe, under oath, that you're not sure if you have the money to hire a lawyer or not, and you wanted to consult with your family to find out whether you had the financial resources to do so. So which is it? Do you have the resources or not? Are you sure you don't have the resources, I guess is the question.
I probably don't have the resources.
I understand, Your Honor, that my client, and he is still my client until the judge signs an order otherwise, is speaking with precatory language. But based on my understanding of Mr. Case's family situation, I do not believe that he would be able to raise the requisite funds to mount the defense that he's asking.
Okay. Well, then the court will appoint a different lawyer to represent you in this case, Mr. Case, and that lawyer then, as soon as I sign the order, the written order relieving Mr. Moore of his obligations to you, Mr. Case, he will no longer represent you, and so he won't be filing any amended motion to withdraw the guilty plea. I don't know if one is necessary or not. Mr. Moore does fine work, so I don't know, I doubt if one is necessary, but that would be the first order of business for any new lawyer appointed on the case, would be A, to sit down with you and figure out, do you really want to proceed to withdraw your guilty plea or not? And B, if you do wish to withdraw your guilty plea, is the motion that's been filed adequate or sufficient for those purposes? So in any event, those are things that the court need not address today. I will sign the order relieving Mr. Moore of his duties in this case. Good luck to you, Mr. Case.
Your Honor, are you withdrawing my plea or?
No, I'm not at this time, sir. That's not a matter I have to address today, and the prosecutor had asked for time to respond to the motion. And so I'm not going to deal with that motion today. And when you have a new lawyer on the case, after the lawyer familiarizes himself with your case, he can do whatever, he or she can do whatever he or she wants, as far as what they deem to be appropriate in representing you. But frankly, lo, these many years ago, when I was a criminal defense lawyer, the first order of business I would have conducted would be to sit down with you and to talk turkey to you about where you really stand in this case and what the benefits and what the disadvantages of withdrawing your guilty plea would be. I suspect perhaps that that's exactly what Mr. Moore did, and it's probably what led to the friction between you and him, but I don't know that, and it's not something I need to know. So in any event, the court is taking under, well, it's not taking under advisement the motion. The court is postponing the hearing of the motion. And we'll see you back in court at some point in the future, Mr. Case. Thank you for being here, sir.
Your Honor, before we conclude this hearing, is Scott Moore also being taken off of the probation violation case 1860-21FH?
They're intimately connected.
All right, so you would, and is that what you want to occur, Mr. Case?
Yeah,
All right, and you, Mr. Moore, have indicated the two cases are intimately connected. Do you believe the breakdown in communication between yourself and Mr. Case with regard to the 2020 case also extends to the 2018 probation violation matter as well?
I do, Your Honor. I believe the resolution of the 2020 case would be dispositive of the 2018 case.
And do you agree with that, Mr. Case?
what's that?
Do you agree with that?
I didn't hear what was said.
Well, Mr. Moore essentially said the outcome of the new 2020 case would probably be dispositive of what happens on the 2018 probation violation case, which seems like a logical position. I just ask you, do you agree with that position, Mr. Case?
Yes, sir.
All right, and do you want the court to allow Mr. Moore to withdraw from the probation case as well?
Yes, sir.
All right, then Mr. Moore will be removed from that case as well. And I assume, Mr. James Case, you would like a different court-appointed lawyer appointed to represent you in the 2018 probation violation case as well?
Yes, sir.
All right, I will go ahead and do that. Now adjourn the sentencing and the show cause hearing on the probation violation matter, the 2018 case. Thank you all for being here.
Your Honor, just one more point I was asked to bring up. On the
Sure.
2018 case, I can only speak to the department on that case, where the 2020 case is ex-prosecutor. The department has requested if bond is posted, that the defendant be placed on some type of tether at his expense. Because he does have 2 failure to appears and a failure to report on 8/19 of this month.
If I could speak to that point, Your Honor, my understanding was that Mr. Case has been untethered all along, or at least I know that, I believe that there was electronic monitoring already part of it.
Okay, thank you.
I still have my tether on.
What he said here.
Thank you, sir. Thank you, Mr. Case. Well, Mr. Moore appears to be right in that regard then, Mr. Case, as he probably was in many other, much of the other advice he gave you as well. But, you know, this is America, like I say, and you're free to make your own mistakes and your own decisions. So that will be the order of the court if bond is posted, continued electronic monitoring by tether will be required.
How much is my bond?
I don't know, sir. We'll be in recess.
All right.